Alrighty, welcome to our webinar, everybody. Why you need adverse action and how Tenstreet makes it easy. My name is Leah Kelly, and I have an amazing crew of adverse action experts on this call today. Joining us today is Shannon Wheeler, our General Counsel. We have Ashley Caton-Peterson, one of our industry experienced account managers, and our Director of Implementation and Account Management, Kim Taken, who also has a ton of industry experience. So first, I want to thank everybody so much for joining our training call today. We run these calls monthly, usually at the end of the month, and they cover various topics such as automation, driver engagement, communication strategy, and so on. So if you haven't been able to attend all of those webinars, or if you want to just see them in review, you can always find them on our events page at tenstreet.com/events and on our YouTube channel as well. I'm going to go ahead and share those links in the chat here shortly after I finish speaking. So keep in mind, though, that this webinar will be recorded and it will be emailed to you at this time tomorrow, so around 2 p.m. Central. You will get, so if you get interrupted or you want to review it later or share it, the recording will give you the opportunity to do that. We also want to encourage you to ask questions along the way. It's really important to us that you get everything you can out of these calls. That's why we do them. They're for you. We want to help you guys succeed in every way that we can. So just be sure to ask your questions using the questions panel in your GoToWebinar panel. And then you also have a couple handouts there too that you want to make sure and grab at some point during the call that Shannon's going to talk about here too. Okay, so here's how our call is going to go today. First, we're going to have Shannon give us a good overview of adverse action, starting with an explanation of why one should have an adverse action process in place. And she's going to cover FCRA lawsuits over time, adverse action step by step, so which she'll go into detail about each of the 4 steps in the adverse action process. And then she's going to tell us a little more about Illinois' new adverse action requirements and tell you how Tenstreet helps you stay compliant, and then touch on some of the biggest gotchas in the adverse action process. And then next, I'll pass the controls over to Ashley, who is going to walk us through how and when to run adverse action. She's going to show us some recommended settings and then talk a little bit more about how to navigate the consumer letters tool and the exception report and process log as well. And then we'll get to our Q&A. You can, like I said, go ahead and ask questions as they come to you, and we'll try to get to them when we can, but you may have to wait for the majority at the end of the call, so stay tuned. All right, and with that, I'm going to pass it over to Shannon.
Great, thank you, Leah. So as always, we start out these calls with a legal disclaimer and that everything that we are providing is for educational information only. Even though I am a lawyer, this is not legal advice. We're just trying to provide you as much educational information as we can. And as always, we recommend that you consult with your own legal counsel on the issues, laws, and regulations that we talk about, and we disclaim any warranties associated with this information. So this is you can go to the next slide, Leah. This is such a great time to hold this webinar. I am so excited to be doing it, and of course, so excited that Ashley's going to demo this later for us. There have been some pretty pivotal changes in adverse action when it comes to the state level, and some new changes that have happened at the state level. And so this webinar came at the right time. Tenstreet has, and as I'll talk about, made some adjustments to our product so that we can help you stay compliant at the federal and at the state level. And it's so nice to see so many people joining this webinar. It's a pleasure to get to talk with you about this. Of course, compliance is near and dear to my heart. It might not, reading the FCRA regulations and state laws might not be everybody else's forte, but it is something that I enjoy, and I like to share that, and I'm glad to have you all on the call today hearing about it. So you might be asking, or your executives might be asking, why do we need to have an adverse action process? Why do we need to pay extra money for this? Why is this important? And these are the reasons that, well, these are some of the reasons. You know, it is 100% absolutely required by federal law under the Fair Credit Reporting Act. And most of you are probably very familiar with the FCRA. It covers everything you do in trucking when you're pulling a consumer report. And just a quick overview, a consumer report is an MVR, a background check, a credit report. It's not just credit reports. A lot of people often think it only applies to credit reports, but it doesn't. Specific to this industry, it applies to MVRs as well. And almost all of you across the board are pulling MVRs on your drivers. And so that's why it impacts the trucking industry so much. Most of you also pull background checks. And then if you pull PSP or clearinghouse, those don't fall strictly under the Fair Credit Reporting Act, but those have requirements around them that mimic the Fair Credit Reporting Act. So if you follow the Fair Credit Reporting Act guidelines with regard to those reports, you're also in compliance with the requirements around those reports. So, and then other reasons, it's required by most state and local jurisdictions. So even within Oklahoma, within Minnesota, within California for sure, and as I'm going to talk about within Illinois, but within probably, I'm not going to say this exactly, but more than 20 states, there is some requirement that has a similar FCRA component to it about sending adverse action letters. One of the main reasons why I say have an adverse action process is because FCRA violations, when they go to court, they are almost always class action lawsuits, and employers are looking at costs for violations for up to $1,000 per violation over the last 2 years. So when you think about the number of drivers that you may have not accepted or not hired based on an MVR and you didn't send an adverse action on them, that's $1,000 per driver. And at the rate that trucking companies process drivers, that number can add up really quickly. Some of the class action settlements that we saw in 2020, I have listed here. If these don't catch your attention, I don't think anything else is, but these were settlements in 2020 alone. 4.75 million, 4.25 million, 1.28 million, and 500,000. Now there were more than that. These are just the biggest ones that I thought might catch your attention. And so it's really important here that I hear this all the time. Why have an adverse action process? Why can I just say they're not a right fit, or they didn't have enough experience on their application? And the reason is because it opens you up to a world of risk. It opens you up to a risk where you're looking at $1,000 per violation. If you have pulled a consumer report, that individual is on that individual, an MVR or a background check, that individual is suddenly on that list for he's not the right candidate or she's not the right candidate to say they're just not the right fit. Drivers do get these adverse action letters from other people they're applying with, and so they know about this process. They know it's something that they can do, and there is a bunch of different law firms out there just waiting, just welcoming with open arms any plaintiff who's ready to bring a case for an FCRA case so that lawyer can assert or try to assert a class action settlement. They're out there. They're even sending drivers out and doing test applicants to see if they if carriers follow the right application process. With that said, these are all the reasons that you should have an adverse action process. If you'd go to the next slide, this is just a really, really good, clear view of what FCRA lawsuits look like. So as you can see, they have continued to grow and grow and grow. And in 2020, they continued that trend and went up more than 5%. I will say this has been very interesting for me to watch. Other consumer litigation areas like the TCPA, the Better Business Bureau complaints, the Fair Debt Collection Practices Act, those all went down in 2020. Who knows why? COVID, all of the things, and litigation trends. This has sort of been an unprecedented time and nobody has known how to predict it. But with the FCRA, they're still going up. And I did do a check this morning to just look at, hey, what are they continuing to do in 2021? And they are still continuing to rise. There are more lawsuits filed in 2021 up till April than there were in 2020. They are up by 3.4% already. So I guarantee you there's going to be another line in 2021 that goes even higher than the one in 2020. We just keep seeing this trend, and I don't want any of our clients to be one of those numbers. So Leah, if you would go to the next slide. So I'm going to talk you through the adverse action. I want to go really quick here because I want to get to Ashley, and I want her to do and show you the demo and what our product can do to take a lot of these burdens off of you. But I do want to just cover quickly the step-by-step process and recommendations about what you should have in your adverse action. So these are the 4 steps. You need to, hey, do we need to send out an adverse action letter and, initiate the process for this subject? And what factors go into that, and then you should send out a pre-adverse action letter, and I'll go into the details of that. You will need to wait a prescribed period of time. I'll talk about that, but you'll need to have some sort of waiting period between sending out the pre-adverse action letter and then between number 4, sending out the adverse action letter. And I'll talk a little bit about what you would need to do during that period of time if an individual contacts you and says, hey, I got this pre-adverse action letter. I probably wouldn't use that term, but I got this letter saying, something in my background check, this isn't true. And I'll tell you what you need to do on that. And then I'll tell you what to do with the adverse action letter. So next slide. Okay, so you've determined that you're not gonna hire an individual, or you're gonna take some sort of adverse action against an individual, not hiring them, terminating them, demoting them. If you're not promoting an employee, or if you're saying, hey, you can't drive anymore, any negative change, that is considered adverse action. The law says if you're going to take adverse action in whole or in part based on a consumer report, that you must send an adverse action letter. What's a consumer report? I covered this a bit. That's an MVR, that's a background check, it's a SIDless. Criminal record, same as a background check, it's a credit report. Employment verifications, we get this question all the time. That's a maybe. It depends on how you get the employment verification. If you go through Exchange, like through the network, make a network request and receive a network response, that is a consumer report. If you've done it by fax or you've called by phone directly to the other employer, the prior employer, that is not a consumer report. The best advice is to treat it like it is, but it is not technically considered a consumer report if you have contacted the other employer directly. But if it has gone through the Tenstreet Exchange network or any other third-party network like that, then it is considered a consumer report. So, and then I mentioned earlier, PSP and Clearinghouse are not technically considered consumer reports, but those 2 reports that you get, if you pull them, have conditions surrounding them, and those conditions require that you follow a notification process that mirrors the adverse action process. So if you're following the adverse action process already and you incorporate that for PSP and Clearinghouse, then you will be meeting those obligations that you have with regard to those reports. And so here's where it comes up, oh, we were just not hiring Jimmy because he wasn't the right fit. Well, if you've pulled an MVR or a background check or both, and there's something negative on one of those reports, the best process, the best practice absolutely is just to go ahead and send the adverse action letter. Just check that box that you've complied with that, and don't leave any gray area open for Jimmy to come back and say, no, it really wasn't because I was not the right fit. It was because of this on my MVR, this on my background check, and you didn't follow the law like you were supposed to. Because that would be open to an interpretation for a jury to decide if you don't send that letter. But if you send the letter, you send the letter, and you're covered, you're taken care of. So it's just absolute best practice. If you have pulled a consumer report on an individual, send an adverse action letter. Okay, so the next step is the pre-adverse action letter. What is this? This is a letter, the first of 2 letters that says, hey, individual, we are intending to take adverse action against you based on this information that we've learned from a consumer report. Some states and some cities require that you list the specific criminal charge, and some say that you must list the specific criminal charge and the basis for your decision. You need to have your CRAs on there. You need to have a current list of the consumer reporting agencies you use on there. So Tenstreet for the exchange network, clearinghouse, you need to list the FMCSA. You need to list NICT if you use PSP. Any other consumer reports that you pull for background checks and MVRs, you need to list those places, and remember to add the company that you use for MVR monitoring as well, so that it's consistent. And then you need to enclose a copy of the consumer report that is the decision may be based on. And that is directly out of the law. That's a quote out of what the FCRA says. What you can do, and what is the best practice, is just to include them all of the consumer reports that you pull. Trucking is one of the most unique industries in which most of the time you're gonna have more than one report, because trucking, you pull so many reports. Most employments, it's just a background check. It's not an MVR, it's not a credit report, it's not a PSP in a clearinghouse. But for trucking, that's not true. For trucking, there can be 5 to 7 different reports that you've pulled on this individual. Include them all. Include them all so that there's not the question of, hey, it really wasn't the MVR, it was the background check, or it really wasn't the background check, it was the MVR, so that they're all included and so that you're covered. There's no harm in sending out all of them. There's no ding against you or your company. There's no argument to come back and say, well, they sent me this report and not this report. That if you send all of the reports, it's there. And that's what our tool does for you. Actually, it's going to demonstrate that for you. Same with the FCRA summary of rights and any state or local notices. You need to have that included to go out with the pre-adverse action letter. Those are key, and our software makes that really super easy and wraps that all up in the process to make sure those are sent out with the pre-adverse action letter within our system. And so I just want to touch on the first point one last time. You are not actually, with this letter, you are not actually taking the adverse action with them at the point in time that you send out the pre-adverse action letter. You're just saying we intend to take adverse action against you based on these consumer reports. What you're doing is you're giving them notice, and then the next step is we're going to give them a waiting period, which gives them the chance to contest that or respond before you actually take the adverse action, which is going to be the final letter. So I just wanted to make that point clear. Leah, if you could go to the next slide, please. So this is the waiting period. You might be saying, what is this waiting period? The FCRA mandates that you wait a reasonable amount of time. What that has been interpreted in the case law is 5 business days, but it's not that simple because nothing ever is. There are state and local jurisdictions that say 7 days. There is Pennsylvania, I believe, or Philadelphia that says 10 days, business days. And so we recommend, and there's nothing that says you can't, you only have to wait that many days. There's nothing that says you would be dinged if you waited 10 days when you only needed to wait 5. So we recommend 10 days so that you have the full amount of time for all state and local jurisdictions, and so it's set, and you can move on from there. And then during that waiting period, you're giving the individual time to come and dispute those consumer reports and say, hey, this wasn't me, that was the wrong John Smith, or that was the wrong charge, they got this wrong. And then they can go back to the consumer reporting agency and actually dispute that and get that removed from their consumer report, get a new consumer report to you, and then, hey, you might suddenly be like, there's another driver, the consumer report was wrong, or it wasn't what we thought, we can now hire this person. So in that case, you would not want to follow up with the adverse action letter. All right, do we want to pause for just a minute for some questions here?
Well, let's go ahead and finish the 4th step, and then we'll pause after that. How's that?
Okay, sure. So I just want to make a note here on the waiting period, both for when you're evaluating whether to take adverse action against the individual and during the waiting period. If you get an individual that comes to dispute the consumer report, you want to follow individualized assessment considerations. So you want to say, hey, what is the job? What is the charge? Look at things like, you know, factors around the charge, how much time it had been, any rehabilitation efforts. Those are individualized assessment processes that you'll want to make sure and consider and document. And then the fourth step is sending the adverse action letter. So if there's no dispute that happens during the waiting period, you don't hear from the individual after you send the adverse action letter, after you send the pre-adverse action letter throughout the 10-day waiting period, then you want to send the adverse action letter. This letter actually says, we are taking the adverse action, meaning we are not hiring you or we are terminating you. What I'm going to cover here in just a minute is that the state of Illinois, this was the new law that went into effect. The state of Illinois has said that that adverse action letter, in addition to on the pre-adverse action letter, that adverse action letter needs to have the specific criminal charge and the basis for the decision. So we've adjusted our tool to be able to meet that for you, and Ashley is going to go over that. I'll talk about it here in just a minute too. So remember that. And then same with your pre-adverse action letter, you want to have a list of your CRAs and the contact information. There's a couple of other things that the law says you need to have in it, and you need to state that the CRA is not the decision maker and cannot explain the reason for the decision. You need to inform them of their right to obtain a free copy of the consumer report, and you need to inform them of their right to dispute the accuracy and completeness of the information. Of course, you also want to enclose that FCRA summary of rights and any state or local notices. We make all of these things really easy for you. Of course, you can have your own adverse action letter template that you provide to us, but we have some sample letters for you. That is what's in the handout that I think Leah posted. And those adverse action letters are up to date with the Illinois requirements and all other 50 states. Of course, you can tweak those, but those are the sample letters that are up to date and current as of right now with the requirements for both the Fair Credit Reporting Act and the state of Illinois and other state and local jurisdictions.
Okay, yay. So we have a bunch of questions here. I did want to get to some of them. People asked, they heard we were going to answer some questions, so then a whole lot came back through. So we're going to try to get to as many as we can. But still, we're going to save we want to save time for Ashley. So just quickly here, Shannon, does adverse action apply to third-party recruiting services or independent contractors?
Great question. If the third-party recruiter is not making the hiring decision, then no, they would not need to follow an adverse action process. If they are making hiring decisions, like if you're not pushing on a candidate, if they know that if the individual knows that they're applying to you and you're pulling the MVR, and then you're not even pushing on that person to the ultimate employer because you're making that adverse action decision, then yeah, you should be initiating that process. It gets a little sticky though, because are you doing it for your company or are you doing it on behalf of another ultimate carrier, another ultimate employer? And so that's something that's a little bit tricky that you might want to work out with the carrier that you're hiring for if you're actually your own third-party recruiting doing that. If you are a staffing agency like recruiting, where you hire them and then place them with a carrier, you absolutely are the decision maker. You are the employer, and you should be sending out the adverse action letters. Independent contractors. So I'm sure you all know and are very well aware of AB5 and other industry issues that are going on with independent contractors, owner-operators in the trucking industry. It's very in flux right now. What I can tell you is the best practice is to go ahead and send that. This is, the law technically does say that it is only for employment purposes, but there's but it's not likely that if you send an adverse action letter that has dual language in it, which ours do, which says for employment or for independent contractor purposes or contracting purposes, I think is what it says, that you're not covered, and that you want to be careful that you're not taking the step to treat an independent contractor like an employee. But if your letter covers you, then you're covered on both ends for it not to be considered employment, but for you also to be covered under the FCRA if that were to be challenged. So my recommendation would be to have an adverse action letter that includes the right language and follow that process on independent contractors as well. Good question.
Okay, thank you so much for answering both of those questions, kind of bulked into one. So if somebody hasn't followed the pre-adverse or adverse action process in a while, let's say 2 years, do you think, is there a way to go back and do that? Could you do that retroactively, or do you just kind of, what's the best practice here? Do you want to just start today, or what do you think?
That is a great question. We have had that question come up as well. What I would do is, there is some risk involved. If you go back and send an adverse action letter to everybody you haven't hired in the last 2 years, there's some risk involved, because you're telling people from 2 years ago, hey, I didn't follow the law 2 years ago. Or you could be implying that, right? So you would want to be very careful about that. And I would not recommend, I mean, this is something that you would want to specifically look at. How many people do we have? How many people do we not hire? How do we want to cover our risk? And those are best decisions in talking with your own attorney that can represent you. But if it were me, I would be looking at who can I send this to in the last 30 days to cover that risk? And then starting today, put in place an adverse action process so that we can start to mitigate that risk going forward, and that we don't have those potential penalties. So that's what I would recommend. And I've had this question come up multiple times, and that, in talking with other FCRA specific attorneys, that's been their take as well.
Okay, thank you. And the last one, and we're going to let you move forward. Do the letters need to be sent out by mail, or can they be emailed?
Good question. They can be emailed. There is nothing that says they have to be sent by mail. However, as Ashley is going to demonstrate, there is some flux with that, because within our own system and our own processes, because for example, I think there is one particular state where MVRs are not supposed to be digitally stored in a third-party system like Tenstreet. And so if you, I think it's Pennsylvania, Ashley, feel free to correct me if I'm wrong on that, but if you have a Pennsylvania MVR, or we can see that the subject has a Pennsylvania CDL, we know, hey, that's going to be a Pennsylvania MVR, and we're not supposed to have that in our system. And so we assume you're going to want to send out that adverse action letter with that MVR and any other consumer reports. And so it's not going to be in our system. So you're going to want to make sure you print that, attach that MVR, and then put it in the mail. There's other things, like we might not have a good email address, or we might not have an email address at all, or something like that, that might be a reason for why it can't go out via email from our system. And so we put it into a ready to mail status so that you can then print it and mail it. And then we make it really, really easy for you to print those, and it prints out all the things you need and put it in the mail. But it can go either or. It's perfectly legitimate to go via email. It's perfectly legitimate to go via mail. Obviously, it's easier, quicker, and cheaper to do as many of those by email as you can.
Okay, great. And then again, remember, I'm having trouble speaking today, but remember that you can go ahead and download those sample letters in the GoToWebinar control panel. We have a couple questions about that, so make sure you get those, and you can look at those sample letters too. And then we can just move right along, Shannon.
Yeah,
we'll get to the other questions here shortly.
Perfect. I'll try to go really quickly through Illinois' new adverse action requirements so that we can get to Ashley. But Illinois came out and said, you have to follow these steps. So if you are hiring a subject that is, an individual who lives in Illinois, the state says you must follow these. And so it would be a really good thing to document your processes here. It says you can, you cannot take adverse action against an individual unless they meet one of these two standards, that it would involve an unreasonable risk to property or to the safety of an individual or the public, or that a substantial relationship exists between a criminal offense and the employment. And so they absolutely mandate that unless it, I mean, those are two very broad areas, but they say unless it falls under one of those two things, you cannot take adverse action against an individual based on a consumer report. So what they say has to be a part of the substantial relationship consideration. So that second prong for a reason why you would be able to take adverse action is they say you have to take into account the length of time since the conviction, the number of convictions, the nature and severity of the condition, its relationship, of course, to the safety and security of others, facts and circumstances surrounding the conviction, the age of the employee, and any evidence of rehabilitation. So if you're going to take action against an individual for any of these reasons, it would be in Illinois, it would be really good to document it. This is in effect, this is what individualized assessment is. And so it's a good practice to do across the board, but it is actually mandated by law in Illinois. They also made some changes to the adverse action process. They said that you have to give not only the notice of the disqualifying conviction, but also the basis for the decision, like the actual reason that you're saying they can't. So if you're not hiring them because of an MVR or something that was not a convicted criminal offense, then this doesn't apply. But if there is something on there that is a criminal offense, and that could be a DUI, then you need to actually state what the conviction was, and that, for example, you could say there was a unreasonable risk to the public based on that conviction, or whatever it is. But you need to really consider that. If it's a theft charge, but the individual is going to be, driving toilet paper over the road, long distances, and not really involve the ability to have, some sort of theft, and, say it's been 6 years since that conviction. Those are factors you need to take into account versus somebody who had, a breaking and entering charge and is going to be, delivering packages to people's doors. So you really need to consider what the offense is and consider what they will be doing as a part of their employment. And you need to set out what that reason is, both in the pre-adverse action letter and in the adverse action letter. That's the key change that has never been there before. And that's something that we've incorporated into our tool. Of course, you need to say, here's a copy of the consumer report, and then you need to have an explanation in that pre-adverse action letter of the employee's right to respond to this notice, to this pre-adverse action letter, before the decision becomes final. And you have to wait that 5 days in between, 5 business days. And so, and then in the adverse action letter, again, you need to state the reason, and then any existing procedures for them to challenge the decision. If you, usually there is a contact, HR at Tenstreet.com or wherever it is. You have to tell them how they can challenge that decision. That is a blank line in that template that I've posted out there. And then you need to inform the employee of a right to file a charge with the Illinois Department of Human Rights. That also exists in the 50-state template in the adverse action letter that I've put out there. And our tool, which Ashley is going to show you, is really great. It now, whatever you type in the little pop-up box, it prompts you if they are in a jurisdiction that is required for one of these things. And then whatever you put in that pop-up box will appear both on the pre-adverse action and the adverse action letter. And if you're asking the question, hey, what if it's not in Illinois? It's okay. It's okay to have it in both spots, even if it's in Oklahoma or even if it's in California, which doesn't require it on both letters. There's nothing that inherently says you cannot have it on both, and it's a better practice. It gives the giving under the FCRA, usually the law looks at, did you give the consumer enough information? And this would be giving the consumer more information. And so my recommendation is establish a practice wherever you are where you're putting at least the disqualifying conviction, but also the basis for the disqualification. Right, next slide. So like I've kind of hinted at, we have updated our adverse action letter. We are absolutely committed to compliance and to keeping and helping our clients with their compliance burdens. We know there's a lot on you, from adverse action letters, FCRAs, releases, drug and alcohol, clearinghouse, independent contractor law, and of course, nuclear verdicts. It's just coming at us from all different angles, and we want to help with these massive compliance burdens that you have. So we make the adverse action process really easy. Any user who initiates the adverse action process, there will be a pop-up box to add the criminal conviction, and if they can type it in, and then any identifying reason for disqualification. If it's in one of the jurisdictions that requires it, Ashley's going to show you there's text in red that says, hey, just FYI, this is required. Mind you, it is not required in any jurisdiction if it's not a criminal offense. So if you're not hiring the individual because they don't have enough experience, or because they had an accident or too many accidents, that's not a criminal conviction. That doesn't have to go in that pop-up box. We're only talking about criminal convictions in that pop-up box. And then that information gets added both to the pre-adverse and the adverse action letter. And then, of course, we've worked with outside counsel and developed new sample adverse action letters that has the updated language for Illinois that you need it. And I would encourage all of you, if it's been a year or 2 years since you've looked at your adverse action letters, even if you already have the process in place, I would strongly encourage you, go look at those letters, go update them. They almost certainly need to be updated at this point. So I think I have one more slide left, or do we want to take questions?
No, let's go ahead and wrap this part up so that we can have time for Ashley's demonstration. And then we'll get to questions. They are important, it's true.
Perfect. So as with everything, there are gotchas in the process. And I get asked about the verbal exception. Quite often it's getting less and less, but if you're wondering what this is, there is an exception in the FCRA which says, this is solely for trucking, which says if the individual has not applied in person, such as that they've applied over the phone, because remember the FCRA was developed in 1970. So in the 70s, you didn't have all the fun tools that we have now that make it a lot easier for them to apply, and they applied over the phone. And so they created this exception that you could do the adverse action process verbally, which means that you would have to follow all the steps that you would have to follow in writing over the phone 100% of the time to individuals. And that's just, it's not really efficient. It's not the best use of your recruiter's time. And then frankly, written evidence that you sent the letter is much, much, much better than just the, yes, I followed this verbally. And so that's not recommended. There's a one-letter process under the federal FCRA law, which says that you can skip the pre-adverse action letter process, and you can just send the adverse action letter within 3 days of taking the adverse action. The problem with that is that it doesn't factor in all of the state and local laws that require the pre-adverse action letter, and it doesn't factor in the PSP requirements or the clearinghouse requirements. So courts are not likely to say that preempts those state laws. And even if they do say it, it would be after a long, hard-fought battle in the courts with appeals. So it's not a process I recommend. Do the 2-letter process. Don't rely on the 1-letter process. Another oftentimes I see is when you don't update your adverse action letters with your current CRAs. So you switch vendors for who you're getting your background checks for, and you don't go back and update both your releases and your adverse action letters. Go check those now. Make sure your current consumer reporting agencies are listed on there. Not conducting individualized assessment, that definitely gets companies in trouble when they do get challenged. They say, hey, are you just not hiring everybody who has any criminal record? That's not kosher either. You want to make sure you're evaluating the charge versus what job they're doing. And then not having a process in place to change that individual's status from not qualified or ineligible to, okay, now we will hire this person. Right now everybody wants drivers, so develop a process for if they do call after that pre-adverse action letter and challenge what's in those reports, that you have a process in place to say, okay, we will reconsider you. And I know all companies right now would be willing and open to doing that because you want to get a driver into that driver's seat. And then I also see companies get into trouble when they do MVR monitoring, but they don't do the adverse action process with the MVR monitoring. So that is a consumer report. If you're pulling an MVR yearly, or I guess monitoring, it's not yearly, but if you're, you get a hit on that MVR monitoring and suddenly you're going to take adverse action, you need to send and follow the adverse action process, give the driver notice, let them contest it. And so with that, I am done. I'm happy to get to Ashley's portion and answer any questions.
Okay, thanks so much, Shannon. That was so informative. That was great. I'm going to pass it over to Ashley. We do have a lot of questions, but I want to make sure she has enough time to cover everything that she wants to cover. And I meant what I said about please ask questions. I really do want you to ask them, and I'm glad to see so many of them. If for anybody who doesn't get their questions answered, we will absolutely follow up with you after the call, just letting you know that, just in case we aren't able to get to all of them. But Ashley, do you see that box in front of you that asks you to take control yet?
Yes, are you able to see my screen?
Yes, we see it now. Great.
Okay, perfect. So welcome, guys. Once you make the decision that you want to move forward with adverse action, your account manager will work with you to set up your configuration, make sure that we program the system to include all of the consumer reports that you guys would like to send out with those letters. Once we have everything programmed inside of the dashboard, when you have the driver pulled up and you determine that you're ready to send adverse action to a driver, you're going to go to process and then add process. Inside of the add process, you're going to see an option that says adverse action letter. Once you select the adverse action letter and you hit start process, this is going to trigger to start the process of sending out your letters. Now, once you start the process, there is a 2-hour delay in the system, so that if someone accidentally has adverse action letter ran on them, you can cancel the process before the letter gets sent. So there is a delay, but once you hit start process, you're going to get this pop-up box. This is the section where Shannon was talking about that, for example, with the state of Illinois, it requires for you to enter in the specific reason for you declining that driver or taking adverse action. And so within this text box, you will be able to type out that specific information. So you could type out that there was a background report in the DUI, and then maybe you can say because it happened within the last year. So whatever information that you need to enter in the section, you could do that. This text box will get associated with the pre-adverse action letter and with the post-adverse action letter as well. So once you have your information in here, you're just going to do send letter, and that is going to queue your driver's letter to the system. Like I said, there is a 2-hour delay before the pre-adverse action letter goes out. So once you do that, we do have the option on this process screen. If you only want certain users to be able to run adverse action letter inside of the dashboard, we do have the ability to limit who can run that process for you. But once you run the process, it does show on your current processes tab. So you can see when the letter was sent out, if you've successfully completed the process, the date and time that it was initiated, and then which user initiated the process inside of the dashboard. Once you run the adverse action letter process, there's nothing additional that you need to do in the system for it to trigger the post-adverse action. It's all set up automated so that the system takes care of that second letter going out for you. Now, inside of the tool, or inside of the system, we're going to have a tool. And so when you log into the dashboard, you go to tools, and then you go to consumer letters. You will work with your account manager to determine who's going to have access to this tool. But within this tool, you'll be able to see all applicants that you've ran adverse action on. So I just ran adverse action on Andy Anderson. So we'll see, first we'll see the pre-adverse action letter, and you'll see that it's pending. And like I said, there is a 2-hour delay, so we'll see when this letter is set to go out. Shannon did mention that we do recommend that there is a 10-day business day delay before you send out your post-adverse action letter. So once you make that determination of when you want that second letter to go out, we'll program it so that it's automated. So this is Andy's post-adverse action letter. It shows pending, and then this is set to go out on June 9th at 4:43 p.m. Central Time. So there's a few different things that you can see within this tool. Shannon mentioned that for the state of Pennsylvania, we are technically, we're not allowed to store those MVRs inside of the database. And so this will let you know if there's a candidate that is required to have that information mailed, or if you have to do it outside of the system. So for this candidate here, if I click on them, it says ready to mail. All I have to do is do print full document, and it will download that document to your desktop for you, so that you can either print it and mail it out, or you can attach it to another email and include the whatever additional consumer reports that you need to attach to this driver's file that are not stored inside of Tenstreet. Once you mail this document, you can change the status, and you can change the status to mailed, and then you'll confirm that you've mailed the document or you've emailed it. And once you do that, it will remove this driver from your report here that lets you know that there is something pending. When you do this print full document, it's going to contain your letters and it's going to contain your consumer reports. It'll all be in one attachment for you. Sometimes you may see another status of error. Whenever you're in the tool, if you see error, this means that there was not a consumer report ran on this driver, so there's not anything for us to attach or to send adverse action on. So if you ever see this error, this report is clickable. You can click on it and it will take you directly over to that driver's file, and that will allow you to review what actually is on the driver's documents tab and what consumer reports we have available. Now, once the driver's letter is sent and it goes from pending, it will show that the letter was successfully sent, and it will remove the driver off of this report. This report is sortable, so if you want to come in and you want to say, I only want to see my drivers that have letters that were mailed, I can click search and it will pull up a list for me. Or maybe I want to see all my drivers that I've emailed a letter to.
Ashley, can anybody else hear Ashley?
No, I'm not able to hear her.
Okay. Ashley, we can't
So
hear you.
this
We
page
lost
is
you on
going to
that.
be really helpful.
Oh, Ashley?
Can you hear me now?
You, yes, we kind of lost you on the end of that last screen. If you wanted to just start over on the screen.
Okay, so on this adverse action review screen, this is going to show you a list of all applicants that have not been moved into a hired status, but have a consumer report inside of the dashboard that has not had an adverse action letter on them. So this tab will help you keep staying compliant to ensure that you're not missing any drivers that need adverse action ran on them, that you haven't moved forward with that process yet. Now, outside of this tool, there is an adverse exception report. This is going to be an automated report that's going to go out. You can designate which users you would like for them to receive the report, but it will give you details on each driver in the dashboard that has had adverse action ran on them. But the tool is really simple. Like I said, once you initiate it on your driver through the add process, it's going to automate all of those items for you. Now, say if a driver contacts you and they state that they're going to dispute an item on their report, and you're not going to move forward with sending the post-adverse action letter, you can initiate that within the tool. So say for my candidate, Andy, that I ran the report on. Say Andy reaches out to me after the pre-adverse action letter is sent, and he's gonna dispute it. I can cancel this adverse action, the post-adverse action letter from sending by pulling up the driver inside of the tool and then just changing the status to cancel. And you'll take the same steps for if you accidentally sent the letter as well before it initiates out. And then this will prevent the system from sending out the letter, the second letter. But it's really easy. That's all it is to the tool. So Leah, if you want to take any questions, we can cover any questions they have about the dashboard or over any items that Shannon covered.
Okay, great. Thanks so much, Ashley. That was great. Let's see. So can you cover again what the ready to mail means?
So for the ready to mail, that means that that driver, say for example, if they live in Pennsylvania, we are not allowed to store Pennsylvania MVRs inside of the Tenstreet dashboard. So that means that that driver lives in a state where there's a consumer report that can't be stored into Tenstreet. So you'll have to download that adverse action letter and attach the additional consumer reports and either email it or mail it to the driver outside of the system, since we don't store those documents. And so on the back end, we have already identified the drivers or the states that have consumer reports that you will have to mail. And so those statuses will automatically change for you.
Okay, great. Thank you. That kind of clears up some other questions I think about working with Pennsylvania. So thank you for that. And I know Kim's been on here too, helping to answer some of your questions. So I'm super glad she's been able to do that since we've got so many. So thank you, Kim. Let's see, what about if they made the decision not to hire based on one consumer report, is it okay if they just send out that one consumer report that the decision was based upon?
From a system standpoint, once we configure it, it's gonna send out all the letters that we have in the configuration. So unless that letter isn't attached to that driver's documents tab, that would be the only way those additional letters wouldn't send. So say if for Andy, we set it up so that the system automatically sends MVR, PSP, and clearinghouse, but we only use the MVR to take adverse action. If the PSP in the clearinghouse report is present, it's going to send all three.
Okay, great. And why is that?
Yeah, from a client compliance standpoint, that's going to be offer the most protection for you, because that would prevent an individual from later claiming, oh, well, it really was, if you only send out one report or the report that you're saying it is, like say it's something on the MVR, but there was something negative on the criminal background check that you also pulled. If you only attach the MVR, the individual could come back and say, well, it was really this background report that you pulled that you made the decision on, and you didn't send me that, and so you didn't comply with like you were required to. So it's an absolute best practice to send them all, send all of the consumer reports that you pulled, and that way you're protected. And it doesn't hurt anything. There's nothing that says you can't send all of the consumer reports that you send.
Yes, thank you. Thank you both. Just to go back to the Pennsylvania MVRs, there's a couple questions about that. Even though Tenstreet can't send those out just due to the restrictions, the legal restrictions, can you store those in Tenstreet even if it's not used in the AA process?
You would want to have a specific conversation with your account manager and or your vendor that is giving you those Pennsylvania MVRs about whether that is allowed or not. That's the best answer I can give right now. Pennsylvania has done audits of certain vendors and said that they could not do that. And then other vendors have not gotten those audits and have not pulled those from third-party systems. So, but as far as our understanding, we are not supposed to have Pennsylvania MVRs, and so we We assume that those are not in our system and not being sent to our system, and that's why we take this action in the adverse action tool.
Okay, good to know. Thanks for the clarification. There were quite a few questions about that, so it is just recommended that you talk to your account manager for your specific case. Individual assessment. And actually, Ashley, can you go back and show us how you got to this tool?
Yeah, so whenever you first log into the dashboard, you're going to go to Tools, and then you'll have a new icon for the users that you've specified should have access to it. It'll say Consumer Letters. And then once you get in Consumer Letters, it'll automatically open up to this first tab here.
Okay, great. Thank you.
And then Ashley,
go ahead, Shannon. I'm sorry.
Ashley, can you demonstrate if somebody wants to monitor this outside of the system, is there a way for them to do that or to get notifications or reports weekly or something on this?
Yeah, that's the exception report, and so it's automated to the specific users. Whenever we go over configuration, you will identify which users you want to have access to that report, and then we will send out the weekly exception report for you.
So if they want, you can get a weekly exception report for how many adverse action letters have not been sent or have been sent, or what the status of those is. You can get a report set up that will be emailed to particular individuals so that they can monitor this.
Correct. But to do like any cancellations or to download the documents to see the different statuses, it does have to be managed in this tool, and then this links directly to the driver's profile.
And of course, we would recommend that this be something, if you're using the adverse action tool, this be something that is monitored for things like ready to mail statuses, pending, and errors. And so can you explain why there might be an error and what would need to be done about it?
Yeah, the error is if there was no consumer report that was ran that we have designated in your configuration that you want to send out to the driver with their pre-adverse action letter. So maybe we said we want to send the PSP and the MVR, but for this driver, neither of those reports have been ran. If you run adverse action, it will come back as an error, letting you know that there's not anything that we can associate with that letter. And so you'll review the driver's file and determine if this actually does need an adverse action letter sent. And then there are some other status. We talked about ready to mail, but if it comes back no contact info, that means that there wasn't an email address listed for us to send this letter off to. And then there's also an undeliverable status. So if we get a bounce back on that email address, then it will come back as undeliverable, and you would want to reach out to that driver, make sure that their contact information is correct, and either resend it to that driver with the new contact information or send it to them through another method, like sending it through the mail.
Great, that's very helpful, thanks. And so we are really getting close to the end of the hour, but since we've got so many people, I'm just going to keep going for a couple more questions. Ashley, can you talk again, or Shannon, either one, about individual assessment and when that's used?
Sure, and so individualized assessment should be done at two different stages. Really at the stage where you're asking, should we be taking adverse action against this individual? So you want to look at what it means is look at the specific criminal charge or the specific thing on the consumer report for why you're not hiring the individual, and evaluate the factors around that thing, time, circumstances, extenuating factors, rehabilitation efforts, and evaluate that against the actual job that that individual would be hired for or will be doing, so that you don't just have a blanket policy that says we don't hire anybody with, this particular criminal charge, no matter what. That's sort of what individualized assessment is, and it should be done really prior to taking even starting the adverse action process, and then after the pre-adverse action letter is sent out, if they dispute something within that consumer report or that you sent them in that pre-adverse action letter, you should do another individualized assessment about, whether to hire that driver before making the final adverse action determination. And Ashley, I know we had a lot of questions, if you would show again how to cancel it, if they do want to, if they say, hey, no, this was wrong, it was not this John Smith, it was the wrong report, and we really do want to hire this guy. So after they've sent the pre-adverse action letter, how they could cancel that within the system. We had a lot of questions around that.
Yeah, so here is Andy Anderson. So I can see him in the tool. His pre-adverse action letter is still pending. So as long as it's pending and it hasn't been sent yet, you can still cancel it out. So I'm just going to click in this row and his information is going to pop in below. And then there's a status option. And I'm just going to change the status to cancel and then confirm I want to cancel. And then the system will no longer send that letter.
Great. And then, so how would it look if there was an adverse action letter? Would they just need to remember to come back in 10 days later and hit cancel on that, or how would that work?
So if they're if the driver calls in and says like, hey, I'm going to dispute this, and you're going to go through that process with the driver and take the individualized assessment, it would be like for this one here, you would just come to the adverse action letter, and this is going to be the post, and you would do the same thing. You would just cancel so that it doesn't send out that second letter.
Perfect. Thank you for showing that.
Mm-hmm. Now, one thing I did want to point out to piggyback off of what Shannon was saying with the individualized assessment is that if there is a driver's answered a question on their application in a specific way and they need individualized assessment, you will see this orange toggle button here, and it will come in automatically orange for you as a visual cue that you need to do individualized assessment for this driver. And then once you do the individualized assessment, you can untoggle it, and this will indicate that you no longer need to do individualized assessment. Inside of the dashboard, primaries have access to a compliance tool, and it will tell you how many drivers you've completed individualized assessment on based on this toggle button here.
Okay, great. Let's see, there's a couple questions on here about how much this costs. So those questions, just you're going to want to route that to your account manager or to your advisor, and they can talk you through what you will need and how we get that set up. It's a really easy setup over here. We get you started really quickly if you don't have this set up already. Yeah, just talk to your account manager about that. I think we're going to go ahead and wrap it up since we are over time. But I wanted to thank everybody so much for joining us. We're going to make sure that you get all your questions answered if you haven't gotten them answered yet. We're going to send out this spreadsheet to our team so we can make sure that you all receive an answer to your question, because we want to make sure that this is a topic that you feel comfortable with and everything is clear so that you can, you're confident in the compliance of your company and that you're doing things right by your drivers. So that said, I just do want to thank everybody for joining us. You'll get the recording and the slide deck in your email tomorrow. And thank you, Ashley. Thank you, Shannon and Kim and everybody for making this great.
Yeah, thank you, everybody.
Thank you, guys.
Bye. Have a great day, everybody.